Well, good afternoon, everybody, or good morning, depending on where you are when you're watching this presentation. I think it's a very important presentation to have at this time, since there's been a lot in the press about the current Listeria outbreak and what has happened to a certain company that produces products which have been alleged to be the cause of the outbreak. What we mustn't forget, however, is the important role that food services play and the risks that food services have and the legal obligations in terms of an outbreak like a Listeria outbreak. So jumping straight in, who am I? Well, I'm Janusz Luterek. I'm a professional engineer. I'm also an attorney and I specialize in food law, and that is why I'm doing this presentation for you. So moving to the first slide. The Foodstuffs, Cosmetics and Disinfectants Act of 1972 is in general the law that regulates everything that is to be said about foodstuffs. For example, the hygiene regulations that you may be aware of, the powers of the inspectors that we're going to be talking about a bit later, as well as product specifications, product labeling, and all those other aspects. What's important to know is that this law obviously was written a long time ago, and although it's been amended numerous times over the years, it hasn't always kept up to date with what has been happening out there. So, for example, under this Act, we have the regulations governing microbiological standards for foodstuffs. Now, one would expect that this regulation would be the one you would turn to if you wanted to know everything there is to know about microbiological standards, and specifically in the present instance, if you wanted to know what are the maximum limits, for example, for Listeria, and how it is to be dealt with. Surprisingly, you may find that these regulations have only one statement which can even generically be said to relate to Listeria, and it talks about that there's a microbiological specification, and that specification provides for the analysis or examination of a foodstuff which may be referred in these regulations for determining the presence of bacteria or other microorganisms which are listed in a column and an annex at the back of the regulation. What is very surprising to most people is that in fact Listeria is not listed in that annex at all, which means that the Foodstuffs Act as such doesn't specifically regulate Listeria, the levels that you can have in a foodstuff, or anything related thereto. So where does that leave us? Well, the Foodstuffs, Cosmetics and Disinfectants Act as such, and remembering that a regulation is less important than an act. An act takes precedence over any regulation, and a regulation is written in terms of an act. The Foodstuffs, Cosmetics and Disinfectants Act states in section 2 that any person shall be guilty of an offence if he sells or manufactures or imports for sale any foodstuff or cosmetic which is contaminated, impure, or decayed, or is, in terms of any regulation, deemed to be harmful or injurious to human health. So, if it's contaminated, it doesn't matter with what. If it's decayed, regardless of what bacteria may be involved, it will be a criminal offense to sell that product. Or if that product contains or has been treated with a contaminated, impure, or decayed substance, or a substance which is, in terms of any regulation, deemed to be harmful or injurious to human health. For example, using an ingredient which is contaminated in the manufacturing of a foodstuff, let's say a meal. So if you took a meat product which was contaminated with Listeria, and you now went and made a salad, and there was meat in that salad, you would be contravening this section of the Foodstuffs, Cosmetics and Disinfectants Act, and in fact be committing an offence. What's important here is to understand the wording, and the wording is any person shall be guilty of an offence. So what the word shall is very important in law. It means that it doesn't matter whether you intended or didn't intend to include this contaminated ingredient in your final foodstuff. If you did include it, you should be held guilty of an offence. Intention is not the critical here. So what can happen if you are found guilty in terms of this provision? If it's the first time that it's happened, you can be fined or you can get an imprisonment sentence of 6 months. If there's a second conviction, the prison sentence or the fine doubles to 12 months. And on a third conviction, it's 24 months or a fine. Now, these may sound very big, but in the big picture, considering that 200 people have died from the current Listeria outbreak, in fact, it's a very minor penalty compared to what the effect can be. So the Foodstuffs and Cosmetic Disinfectants Act further provides in the hygiene regulations, most of you would be aware of the hygiene regulations, so-called R962, which is currently actually being replaced, but for our purposes, we still need to deal with R962. There it states that subject to the provisions of Sub-Regulation 2 and Regulation 15.5, but here's the important part, no person shall handle food or permit food to be handled on premises in respect of which a valid certificate of acceptability has not been issued or is not in force, or in contravention of any restriction or condition or stipulation contained in such certificate of acceptability. So you must have a COA in place in order to operate a food services company. No person shall handle the food or permit the food to be handled. It means you cannot employ people or direct people or even allow people to handle food if there's no COA. Who has this responsibility? So further in these regulations, it says that the person in charge of any food premises wishing to obtain a certificate of acceptability in respect of such food premises shall apply in writing to the local authority in whose area of jurisdiction the food premises are situated on a form containing at least the particulars that are substantially the same as those contained in this particular form. Now, the keywords here on this slide for you are person in charge of any food premises. So there always has to be a named identifiable person on the COA who is in charge of a food premises. And if you are working in a food service company, you will go look at your COA and you will find there's a person named, and more importantly, that person's ID number also appears. So certain companies have a practice where they will name someone in head office and put their ID number on the COA. As you will see in the slides that follow, that is a very, very dangerous practice, in particular for the person who is named as the person in charge of any food premises. So further in these regulations, it says that a certificate of acceptability shall be displayed in a conspicuous place for information of the public of the food premises in respect of which it was issued. So the COA is not issued to a company so that they can trade anywhere. It's for a particular purpose that it's issued. It then says that if the person in charge of food premises is replaced by another person, such person shall inform the local authority in writing of such replacement within 30 days after the date, and then they need to get a new certificate of acceptability issued in the new person's name. You cannot simply leave somebody else's name on the form who's no longer there. And no person may make any unauthorized changes or additions or forge a certificate of acceptability. Now, I thought I need to mention this because I have had people tell me before, well, in that case, they will just themselves change the certificate. They will simply cross out the previous person's name, put the new person's in charge's name and their ID number. Now, that act in itself would be a criminal offense, so don't do that. You have to go through the formal process of applying to the local municipality or local authority to get a new certificate of acceptability issued. So, let's talk about the criminal liability of a person in charge of premises. Because now that we know who this person is, how do we identify them? How do we know who they are? What liability does that person have? And as I said, the certificate of acceptability has the name and ID number of the person in charge of the premises thereon. So the person in charge of premises where unsound, unwholesome, or contaminated foodstuffs are sold can be prosecuted under the FCD Act and be sentenced to the fine or the imprisonment, as I showed you on the previous slide. So it is that person who is in charge of the premises who will in fact be prosecuted. Not somebody in head office had told them, don't worry, just carry on. We'll put it in next year's budget to sort out the hygiene problem. You are in charge of the premises. You need to make sure that you comply with the law. It's like a pilot of an aircraft. If the aircraft is not in good condition, you don't take off. It's not an excuse to say, oh, but head office said I must go anyway. You are left in charge. You are left liable. That is really important to understand. So I have dealt personally with the prosecution previously, where I defended a prosecution, where a butchery manager was charged criminally on the basis that meat had been sold which was contaminated, and they didn't prosecute head office, they didn't prosecute him, they didn't even prosecute the store manager. They prosecuted the butchery manager. Because in that particular setup, the butchery was operated as a separate unit, and the butchery had its own COA. In another circumstance, it could be the store manager who gets prosecuted, who may know nothing about how a butchery is being run. So, what are the defenses against being prosecuted? What it says in the Foodstuffs Act is that no person shall be convicted of an offence that they are selling or importing any foodstuff in contravention of this Act if he can show that he or his employer acquired or imported the article in question under a written warranty. That written warranty has to be issued by a local South African address. So you cannot import a foodstuff from China and get a warranty from China and then try and rely on that not to be prosecuted when it turns out that it's contaminated. You would need a local importer to give you that warranty so that if it is in fact not true what they say in the warranty, that person can be prosecuted. South Africa cannot prosecute somebody sitting in France or in Italy or in China. Next thing that you would have to prove if you don't want to be prosecuted, that at no relevant time did you have reason to suspect that the article in question was a prohibited article. So we are now, for example, talking about Listeria outbreak, and the minister announced that a particular brand of polonies and Viennas are likely to be contaminated with Listeria. You cannot now be given a warranty by someone who says they warrant that it doesn't have Listeria, because you would fall foul of B2, which says that at no relevant time did you have a reason to suspect that it was a prohibited article. The minister already announced that these are contaminated products. You cannot now sell them. And then finally, even if you have no reason to suspect and you got the warranty, you are only protected against prosecution if you sell it in exactly the same condition as you bought it. So, if you acquire frozen burger patties from South America, you obtain a warranty from the importer in South Africa, and there was nothing in the press at all about any contamination in the source country where you got your frozen burger patties from. But you're not selling frozen burger patties. You are breaking the pack open and you're cooking them individually. Therefore, this exemption to conviction does not apply, because you would not have complied with B3 in that you didn't sell it in the condition which you inquired or imported it. So this warranty really only applies in the case where you buy a product and you sell it as is and you have a warranty in place and you have no reason to doubt that there's anything wrong with the product. Okay, so looking further at the Foodstuffs Act and the regulations thereunder, if we look at the powers of inspectors regulations under this Act, which must be read together with the hygiene regulations, because who enforces the hygiene regulations? The hygiene regulations are enforced by the so-called environmental health practitioners, otherwise termed inspectors, and they have their own regulation number R328, but they are in effect enforcing regulation R962. So what it says in R962 is that if an inspector following an inspection of food premises or facility is of the opinion that such circumstances exist with regard to the food premises or facility or any other activity that they constitute a health hazard and that the continued use of the food premises or facility or the activity should be prohibited, the local authority may summarily prohibit the use of the food premises or facility for the handling of food or any other activities that relate to the handling of food by serving a written order on the person in charge. So an inspector comes, maybe he's had a complaint, maybe he hasn't had a complaint, maybe he just decides to do a routine inspection. This EHP inspects your premises and is of the opinion that what you are doing there is either a danger to health or that continuing doing what you're doing will constitute a health hazard. They have the power to close you there and then. They issue a certificate and say, you may not continue operating this facility until you have done what I'm telling you to do, for example, a deep clean, whatever the issue might be that they want you to address. But very importantly, it can lead to the complete cancellation of your certificate of acceptability of your premises if you don't rectify the problem in a specified time. So they may give you, say, 30 days to comply with this written order. And if you haven't complied with it in 30 days, they'll take away your COA completely and you have to start from scratch. So if an inspector is of the opinion that in relation to food premises or foodstuffs contemplated in the Act, activities or conditions exist which are dangerous or harmful, or likely to be dangerous or harmful to health, or which are likely to favor the spread or impede the prevention of a foodborne disease, he or she shall issue a written order in a format provided, signed by him, and addressed to the person in charge of such premises, and there you will be instructed that you must rectify the problem completely or within a specified period, otherwise close your facility. Now, what's important here is if an inspector is of the opinion, the inspector doesn't have to be 100% certain. The inspector can come and look, and in his opinion, it poses a health hazard. Solely in his opinion. Obviously, the opinion must be justified by what is happening in the facility. He can close you there and then. He doesn't need to wait for a month for results to come back from France to prove what strain of Listeria you have in your facility. The public health is overriding here. The harm caused to you if he is wrong is far less than the harm caused to you if he caused to the public if he is right, but you are allowed to continue trading. For example, I've had situations with bakeries where a bakery in one suburb, in what we would consider a suburb in Cape Town, is selling bread. They are displaying it on a big wooden table. The loaves of bread are lying there. Everybody who walks past can poke it with their finger, pick their nose, poke it with the other finger. No problem at all. But across the road, there's an EHP. And in his suburb, he does not allow bread to be displayed open. He insists that the bread be kept away from the public, that it be handed to the public only in a bag. And when confronted and said, but how can you be applying this law so strictly on your side of the street, but the competitor on the other side of the street is simply selling bread completely open to the public? His answer was, my power lies in the municipality that I work for. I have no powers outside that municipality. On the other side of this road is a different municipality. And if you have a problem, take it up with that municipality. So it's an opinion of an individual. A particular inspector has an opinion. And that particular inspector then has the power under his opinion to order you to do something or even to close your factory, to close your business. Let's move on to what are the liabilities. So we've spoken about the legal obligations. Now, legal obligations are one thing. What happens if you don't comply? Well, they can close your business, they can close your facility, or they can fine you. But let's face it, these fines are quite small. In general, they don't close your facility forever. They tell you to deep clean and you open a couple of days later. But there's another law, the Consumer Protection Act. Now, the Consumer Protection Act is a very powerful law. It was promulgated in 2008, and its purpose is to protect consumers and to give consumers the power to get compensation for any harm that has been caused to them. And let's first go and look at Section 55 of this Act. There's a warranty of good quality and safety. And what Section 55 in a nutshell says is that every consumer has a right to receive goods that are suitable for the purpose for which they are intended. Well, food must be safe and nutritious, are of good quality and free of defects, will be usable and durable for a reasonable period of time. Okay, that's really probably not that relevant to foodstuffs. Must comply with any applicable standards under the Standards Act. Now, if you contravene this section, intentionally, one should add, then you could be prosecuted by the National Consumer Commission. And if the National Consumer Tribunal finds you guilty of a so-called prohibited conduct, the fine can be the greater of 1 million rand or 10% of a business's total turnover. So not the turnover of your particular shop, not even the turnover of your particular division. If you're a division of a very large business, it could be 10% of the total business's turnover, which could be astronomical. If you compare that now to the possibility of a 6-month prison sentence or a 50,000 rand fine, that under the Foodstuffs Act, that pales into insignificance. There's also further provision, and that is for liability towards consumers. So Section 61 of the Consumer Protection Act introduced the concept of strict liability. What is strict liability? Before this law came into effect, it was required that for a consumer to succeed in a court case against a company, they would have to prove that the company was negligent. In other words, they ought to have known some or other harm would be caused. They didn't take the steps to prevent it. But there needed to be this link that there was something you didn't do that you should have done. Most consumers, maybe I should say all consumers, are completely unable to prove such a thing. They cannot prove that a company behind closed doors didn't do something they should do, that their HACCP system wasn't correct, that they didn't use the correct cleaning chemical. They should have known that QACs don't work as well on Listeria anymore as they used to. Joe in the street doesn't know that. Joe's lawyer doesn't know that. So the Consumer Protection Act introduced strict liability. Now, strict liability says the following. The producer or importer, distributor or retailer of any goods is liable for any harm caused, wholly or partly, as a consequence of supplying any unsafe goods, supplying goods that have a defect or hazard, or inadequate instructions or warnings provided to the consumer regarding any hazard associated with the use of any goods. Now, in the case of foodstuffs, obviously that last point would relate to proper handling and cooking instructions, reheating instructions maybe, storage instructions. There are many types of instructions that you would need to give a consumer to ensure that they do not get listeriosis. Let me give you an example. Most people would tell you that bacon is not a listeria problem because at the end of the day, you cook bacon before you eat it. So listeria will be killed. To my surprise, I found out that in fact there are quite a number of people that eat things such as raw bacon, raw boerewors. So when you are selling your bacon and your boerewors, which has some listeria, but you are not concerned because in your view, this is going to be cooked anyway. Very important, put a warning on the product. Do not eat raw. Cook well before eating, or words to that effect. You cannot simply assume that somebody will cook it before they eat it if you haven't said they have to cook it before they eat it, because they might choose to eat it raw. You could pick up liability in terms of this section through inadequate instructions and warnings. But what's important to note is negligence doesn't come into either A or B or C. It's simply cause and effect. Your product caused me to get listeriosis. The fact that you did or didn't do everything you could have possibly done or anything that's known to man is irrelevant. Your product made me ill. Your product killed my child, killed my parent, whatever the case might be. You have no defense by simply saying, oh, but we have HACCP, we've done what we can. And then finally, the Consumer Protection Act also makes provision that simply being a service provider also makes you liable. So a caterer, a canteen, a restaurant doesn't have as a defense to simply say, oh, well, we simply sell what we are sold. That is not a defense under the Consumer Protection Act. So the Consumer Protection Act then goes on to say that if more than one person is liable in terms of this section, their liability is joint and several. So if the farmer produced the animal which has a disease, went to an abattoir, went to a distributor, went to a butcher, went to your business, in reality, everyone in that supply chain could have liability. And that is what this section is saying, is that in a case like that, everybody would have to contribute towards what the consumer's claim is. The only defense to a strict liability claim is what I'm going to talk about now, and that is section 61.4. It says, liability of a particular person does not arise in terms of this section if, and I should say only if, number one, the alleged unsafe product characteristic, failure, defect, or hazard did not exist in the goods at the time it was but supplied by that person to another person alleged to be liable. So a poultry factory does all its testing, it freezes the chicken, it records all the temperatures. They can show that at the time the chicken was sold and delivered to a retailer, there was nothing wrong with the chicken. They then would not be liable if a consumer ate chicken and ended up with food poisoning. Because they could show that when they handed it over to the retailer, on a balance of probabilities, there was nothing wrong with the product. It must be the retailer's fault. In your case, possibly, as a food services, you've cooked your food, you've supplied it hot, it's in a bag, you've now given it to the consumer. You don't know that they're going to put it in the boot of their car, go park somewhere, get distracted, it lies in the boot of their car for 4 or 5 hours, but then take it home and feed it to their child, to their sick granny, who then dies. So you would need to have proper kitchen records to show time, temperature, storage, so that you can show that in the normal course of events, it is highly unlikely that the problem arose in your kitchen. In the absence of those records, you will be liable to the consumer. And then finally, there is one defense, and that is that it's unreasonable to expect the distributor or retailer to have discovered the unsafe product characteristic, failure, defect, or hazard, having regard to your role in marketing the goods to consumers. Now, let's be clear. If something smells off, there's no defense. You don't need to have a laboratory. You don't need to be a big corporation to know something is wrong with this particular product. If it's slimy, it doesn't smell right, it doesn't look right. But when you're a bigger business, you're obviously going to, at the very least, rely on certificates of analysis from your suppliers to make sure that the products are fine. We already know of a Listeria outbreak. Everybody now should be demanding COAs for Listeria, or alternatively, where the type of product allows it, be doing your own testing, at least a positive, negative type test. So that's the only type of defense I can see where it could be unreasonable to expect you to do more. So, you know, your fresh chicken arrives. You certainly can't wait a month until a test comes back from France to tell you if you've got Listeria SP6. But certainly there are things you can do to ensure that the product is as safe as it possibly can be. And then what would you be liable for? And now we're going to start talking big numbers. So in terms of the Consumer Protection Act, you would be liable for the harm caused to a person either by the death or their injury to that person or their death, illness of anyone, and any economic loss that results from harm contemplated above. So if I'm ill and I'm unable to work for 3 weeks, 4 weeks, maybe I lose my job, maybe I'm permanently disabled, you would be liable for supporting me and my family for the rest of my life. I read a newspaper article yesterday about a lawyer who gave an opinion that all the mothers who lost babies due to the listeriosis would be able to claim 1.5 to 3 million rand each. Now, I have some very serious doubts about that quantity, that amount, but there it is. It was said in the press. So we know that a large proportion of the people that died from the Listeria outbreak were in fact babies. So if you simply multiply that by 3 million, you're really up at probably 300 million rand, just that claim. So the current claim that's been spoken about in the press from the current Listeria outbreak against enterprise stands at about 2 billion rand. That's 2 with a B, 2 with 9 zeros. 2,000 million rand. That's how much they are saying they're going to be claiming on behalf of all the people who were ill or who died. So we get to a very important topic, which is recall. Now, recall is critical. You'll note from the Listeria outbreak, the minister announced on the Sunday that all the polony and Vienna and ham products, etc., produced at enterprise should be recalled. On the Monday, the products were already being recalled. There was no delay. There's no time to delay when something like this happens. And recall must be urgent and complete. Product must be tallied. And there are, in fact, guidelines on how one does such a recall. Although clearly in the case of something like the Listeria or other foodborne illness outbreak, a much greater degree of urgency is required than that provided for in the Consumer Protection Act. But the Consumer Protection Act says that it makes provision for both voluntary and compulsory recalls. Very importantly, you cannot simply withdraw a hazardous product quietly. You need a notice to supply chain and consumers of the recall and the reasons for the recall. So a couple of years ago, there was a company that produced pool chemicals. They produced those floaters that you throw into a swimming pool and that they release chlorine slowly into the water. And those plastic containers, you'd think they were a very innocuous type of product, had a problem, and they were splitting in half. And what was happening is the tablet was falling to the bottom of the pool. Of course, you know, our children are, they'll dive in, they've had to fish out this very toxic chlorine tablet from the bottom of the pool. So what was really required was a recall. They should have had a widely publicized recall. Do you have one of these in your house? Do you have one of these in your pool? Take it out immediately and bring it back, etc., etc. Now, but what did this company do? They published ads which says, do you have one of these white pool floaters? We've got a special for you. Bring them in and we'll give you 2 blue ones. Now, that is not a recall. So if anybody had been harmed by the chlorine tablet, they would have had a perfect case against this company because the company failed to do a recall. So in terms of the recall, you may want to keep the fact that there's Listeria in your factory quiet. So I get these phone calls, and maybe less now, but certainly when the announcement was made by the minister, I received quite a number of calls. The companies asked me, they said, look, we found Listeria in our factory. We didn't find any in the food. We don't want to scare everybody, but what we want to do is we want to get the product out of the market quietly. Can we do that? Now, it's a decision you've got to make, because if it's a safety recall, then in terms of the law, you have to notify the National Consumer Commission. You can't do it quietly. You cannot decide that it's a recall, but you'll do it quietly. Why can't you do it quietly? Because you have to publicize it widely. You have to go in the press, you have to be on TV. You've got to let everybody know to stop using the product and return it immediately. And one of those steps is to inform the National Consumer Commission. The National Consumer Commission will require you to have a recall strategy approved by them, and that will be the first step to doing a recall. And there's an obligation to take recalls seriously, and if you don't, prosecution under the Consumer Protection Act could follow. So, how do recalls work? A National Consumer Commission ordered recall, as for example happened with the polonies and Viennas. The cost is now object to the National Consumer Commission. Consumer safety is prime. They don't care about practicality. They order you, go in the press, go on television, go to the shops, make sure you get everybody notified in all the languages to get this product out of the marketplace. Typically, not in a case like a Listeria poisoning or a risk of other foodborne illness, but typically they would first give you an opportunity to do a voluntary recall. If you fail, they then force you to do their recall. A voluntary recall is a much better option for a company, because if you rather approach the National Consumer Commission and you say to them, look, we found Listeria in our factory, none of the tests show it's in any of the food stuff, but we are going to do a recall. Here's our plan. We're going to take the following ads out. We are going to do the following things. We want to get the product out of the market for the sake of consumers. The National Consumer Commission is most likely going to agree to your proposed plan. They may tweak it slightly, but they're certainly not going to be as aggressive as they would be if they had to come and find you to order you to do the recall. So it is really important to understand that voluntary recalls are very important, and it's a very important tool to use if the need arises. It can also help to reduce reputational harm because what happens is that public sees you taking it very seriously. No one is ordering you to do a recall. You are doing it because it's the right thing to do. So a recall notice must comply with the following. It cannot state that it's a voluntary recall. Now, it might sound counterintuitive. I've just spoken about a compulsory recall and a voluntary recall. The problem is if your ad says at the top, voluntary recall, the public will assume what you mean by that is that they don't have to bring it back. They can only bring it back if they want to. So the word voluntary may not appear anywhere, even if it's a voluntary recall. You need to have a clear product description with batch numbers, dates available for sale, what the product is, a picture of the product, ideally, what the defect is, if it's visible, if it's something you can show in a picture, and do it in a way that the public can understand. So you need to state what the hazard is, can cause foodborne illness. You could lose your baby, unborn baby, your aged parents can die from this, etc. You need to say exactly what the hazard is. You can't sugarcoat it. There needs to be a what to do section. For example, cease using immediately, return the product, even if it's half eaten, for a full refund, don't dispose of it, etc., etc. So you recall this polony recall. People could bring back just the tail piece of a polony. They would get a refund for a whole polony. No one was telling them, well, it's a kilo polony, you've returned 200 grams, we're going to refund you 20%. You bring back the packaging, you get a full refund. You want to encourage people to bring it back. And then, of course, you need proper contact details of who to contact if you've got queries. We now get to a very, very important topic, and that is Consumer Protection Act class action lawsuits. You would have read about this attorney called Richard Spoor, and he had threatened to start class action lawsuit against Tiger on behalf of all the people who were ill and who died. And this was in terms of the Consumer Protection Act. And what this law has finally allowed people to do is that consumers no longer have to sue a company one at a time. So before this law came about, if there were 20 people who all got food poisoning, all 20 people would have to sue a company. All of them would be named at the top of the summons, and all 20 would have to pay legal costs. What the class action lawsuit permits you to do is a person can act in terms of a class of known and unknown people. So they will know there's 1,000 people who got ill and 200 died. Chances are there's probably another 3,000 who were ill and another 400 that have died that no one has as yet linked to this illness. And in fact, more may die in the future from this outbreak. So what you do is you bring a court case on the basis of all the people who you expect to still get sick, using statistics and an actuary and scientists and so on, and you sue the company to provide funding for the future to be put into a trust fund administered by the lawyer that runs the case. And at the end of the day, consumers will no longer have to go and fight with the company for their medical bills, their support, and so on. They would go to this trust fund, and if they can present a proper case, they would be paid out from the funds collected on their behalf by this lawyer. And that's called a class action lawsuit. So currently, over 1,000 illnesses and 205 deaths could constitute a class under the Consumer Protection Act for class action. In fact, it has. One has already been started. As I said, many victims are probably still unaware that they got ill from that. You know, I've already heard people saying, you know, my Uncle Harry, he actually last year, you know, he suddenly got ill and died and nobody knew why. Maybe he had Listeria. Maybe we should go and have him exhumed and check him. Maybe we're going to find he actually ate bologna and died of Listeria. So there are those people that are still going to come out of the woodwork. The litigation costs can be very, very high, but the amount of money that the attorney can make could also be very high. So it's worthwhile for a lawyer either to fund the case himself or to get an investor, a so-called venture capital funder, who says, okay, I'll fund this litigation, but I want a share of the proceeds at the end of the case. Now, in South African law, it's not that simple to share the capital sum. So if you get 2 billion rand to support the widows and orphans and etc., you can't take a chunk of that and give it to the person who ran the court case. They're probably only entitled to twice what their normal fee would have been. Where they will really make their money is from running the trust fund. So if they're administering 2 billion rand, and they're entitled to take a few percent a year of that 2 billion rand. They will make their money from administering the fund and not from the litigation. So class action is a very serious risk to your business because it creates an incentive for consumers to litigate. As I said, I've already heard consumers saying, you know, maybe when I was ill it was Listeria, maybe when so-and-so died it was Listeria, maybe we should join the class action. It creates contingency work for even the highest level of attorneys. What I mean by that is the average consumer can't afford a top attorney in South Africa. But as a class action, they can afford the very, very best. Because if there's 2 billion rand at stake, the best attorneys that do that type of work will be involved. It's a risk to even the largest company. And of course, the real way to save yourself, besides doing the best you can in running your business, is to make sure you have the right type of insurance. So let's talk a bit about ethics and limiting liability. So Listeria has a long incubation period. I mean, I've heard between 3 and 70 days, I've heard 1 day, but let's say on average it's 21 days. So you often wouldn't know that the product you sold caused somebody's listeria until listeriosis until much later. So if the source of the pathogenic infection is known, conduct a voluntary recall and report it to the NCC. So if you then realize that, you know what, the product I've been selling has been making people ill. Well, it might be quite difficult if you look at the first point on the slide. But if you're aware, conduct a voluntary recall. It's really a requirement, but also ethically you should do it. And the question is, could you sleep at night knowing someone was very ill or died due to a failure to conduct a recall? You thought it's not that serious. Meanwhile, 200 people have died. For you, it was a budget item. That machine that doesn't clean so well, we'll replace it in 2021. We'll put it on the budget. In the meantime, 200 people died. How would you feel about that? And then, of course, you need to carry insurance for this type of event because there is really no way of seeing it come. You know, it's like a meteor falling from the sky. You think everything's fine. You've got HACCP in place. You're being audited. Everything looks hunky-dory. You're doing everything that you think you can. And suddenly people start dying and it turns out you're the cause. And the only way you can prevent that is to protect yourself is by carrying insurance. Let's talk about quickly the Health Act and notifiable medical conditions. There was quite a lot said in the press that listeriosis has been added to the list of notifiable medical conditions. And I've had laboratories phoning me and saying, we found listeria in a food sample somebody sent us. Do we now have to declare this to the minister, to the health department? So it's very important to know that a notifiable medical condition has to be a medical condition. So it's only relevant to medical institutions, doctors, nurses, pathologists, and the like, who are diagnosing a patient with a medical condition. It doesn't apply to a swab of a floor or a sewer or even a foodstuff. The foodstuff has no medical condition. There's no obligation to report a swab result unless it's requested from a patient. And that's all. Thank you very much. If you have any questions, I'm unfortunately not available today, but there's my email address. You must feel free to send me an email, and as long as it's not a long question that requires legal research, I'll be happy to answer it. Otherwise, you know how to get hold of me. Thank you very much for your attention.